Right. Good evening, everyone. My name is Sipan Zadorian, and I'd like to call this meeting to order. Today is the regular meeting of the Landlord Tenant Ad Hoc Committee taking place on Wednesday, May 24th, 2023 at 6:05 p.m. May we have roll call, please?
Committee Member Bertollet,
Here.
Herpetin,
Here.
Marchand,
Present.
Sun,
Here.
Tavanyan,
Present.
Sarganian.
Present.
We are saddened to report that Committee Member Razmik Grigorian passed away on Tuesday, April 25th, day before our last meeting that we held. Razmik Grigorian was born in Iran after his grandparents escaped the Armenian genocide. He received his Bachelor of Arts degree from the Metropolitan University in Manchester, England, and his diploma in Art and Technique of Filmmaking from London International Film School. He then immigrated to the U.S. and spent the rest of his life in California. He is the longest-serving commissioner, having served 13 years on the Arts and Culture Commission in the city of Glendale. Razmik was an art enthusiast, an active member of his community, and an avid traveler. He traveled to nearly 70 countries and spoke Armenian, English, Persian, and Spanish and French as well. We are, as we said, we are saddened to report that. We did report the information to City Council. I think they're still mulling the situation with regards to whether or not they may or may not appoint a replacement. I think, at least from staff's perspective, we're so close to the end here, I don't know if it would necessarily be something that would be fruitful at this late in the stage. And given the cooperative relationship that the committee has with each other and how things are going, it may not be needed, but we'll see. I don't know if there's anything else anyone would like to say. If not, we can move on.
All right. Next item on the agenda is regular business agenda. May we have the report, please?
The agenda for the May 24th, 2023 regular meeting of the Landlord Tenant Ad Hoc Committee was posted on May 19th, 2023 on the bulletin board outside of City Hall.
All right. Next item is approval of minutes. We have minutes from April 26th regular meeting of the Tenant Landlord Ad Hoc Committee. Does anybody have any comments? Can we get a motion to approve?
So moved.
Second.
Next is oral communications.
We have no callers and we have no speaker cards.
All right. Next is business agenda item A, review of the committee comments and suggested changes to the chapter 9.30.
Members of the committee, we have now come to a place in the process where we have received and reviewed the comments from the committee. We have distilled them down to the following document that we'd like to review with you. The next step in our process would be to take a report to the City Council to describe the progress that has been made, the comments that have been made by the committee, the potential areas of change or further review. And at this point, we would like to go through the draft, which will ultimately become a part of the report that we produce to council at a future meeting. Of course, you will all be invited to attend that meeting. You would be free to make comments during the meeting, discuss your viewpoints specifically. But if that's okay with you all, maybe we can start going through the document and we can answer questions, we can make changes, we can add things. If you've changed your mind about certain areas, we can certainly incorporate those too. So is there any questions about the process, or should we just get started? So we started the process with starting a review of the just cause eviction ordinance. And over the years, the capabilities of the ordinance had somewhat expanded, and so there was a suggestion that we should perhaps consider changing the title of the ordinance. Some of the ideas that came about were rental rights program, residential rental rights program, or residential hiring of property. I think what I'm going to do is stop at each one so we can speak about them rather than going through the whole report. And I'll look, and if someone wants to say something, then I'll pause. But if you don't have anything to say, I'll just keep going. Okay. Then we looked at section 9.30.010, the legislative purpose. And there was a suggestion that perhaps we should revisit the overall, we should revisit the legislative purpose and perhaps update that if necessary, and provide an updated version of the legislative purpose. The next area where we had a discussion was in the definition section, .020. And we looked at two specific definitions, both having to do with the definition of rent, and perhaps looking at rent from two different, making a distinction in the formula of the rent, one that would include in the definition of base rent those reoccurring charges such as parking, storage, and exclude from it usage charges such as utilities and those types of charges. So that was another area of discussion that we had.
Yeah, I think the one thing, though, that I would want to make sure that we clarify is with regards to, say, parking and storage and things of that nature. It's not unusual for tenants and landlords, once they start a tenancy, to perhaps, let's say they have one parking spot or one area of storage, and then as the use may increase over time, where the person wants a second parking spot. So I think that this should be should specifically define scenarios that are initially negotiated at the inception of the lease. Because if you were to negotiate a separate storage, you can, it essentially acts differently. So, but if you say essentially to the tenant, this is how much you pay for parking, this is how much you pay for, storage, and this is what comprises the unit at the start of your lease, that should be established as essentially what those encompassed charges are as rent. Okay.
Right.
One thing also, in the other cities that we've seen, we didn't really touch this, but let's say if at some point in time the tenant elects, I don't need parking, or they want to pass it over to a neighbor. At that point in time in other cities, that's considered a reduction of services. Or if you don't have appliances or something like that, sometimes people may not want a laundry unit, and it comes with it. I think we should just leave alone the fact at that point, unless the parties want to negotiate it amongst themselves, that if there is a mutual change that's made between the parties where there is a reduction, likewise, just as you would have a second parking spot and the tenant says, I want to go back to one parking spot, that whatever is agreed amongst the parties, that essentially should be presumed to be the final consideration that both have agreed to. It shouldn't be something that opens the door for further, hey, you took away my parking, and now I want you to take $50 off, not $25 off. So if the tenant wants the reduction at that point, they're not obligated to. But if they say to the landlord, look, I'm willing to give you this spot if you need it for another tenant, or if there's a shortage of parking, and landlord and tenant agree, hey, we're going to agree to $25, that their discussion resolves that dispute, so that later on they don't come back and say, you came and forced me to do this or do that, and now we're left with the city having to essentially adjudicate, if there's been a reduction of services or not. Of course, if it's done unilaterally, where at the end of the lease, let's say the landlord says, I'm going to take away the parking, then at that point in time, that's a different scenario altogether. But sometimes what you have is these situations where there's some discussion, and then they go back and they start arguing on valuation. Well, you know, I gave you that, but you rented it to the other tenant for an extra $100, and I only got 25 bucks off my rent. So I want you to give me now $50 off my rent every month. And I've seen those scenarios where, you know, the tenant will come back, or the landlord may come back and say, well, this or that, you know. Same thing also with parking is concerned. So if the landlord was to say, for instance, I will agree to give you a second spot and I'll give it to you for 25 bucks. And then the prospective tenant says, hey, I'll take it for 100, that the presumption that's made between the agreement between the parties essentially stays, so that people can't switch. Because that's really where the problem comes up, is when there's a better opportunity, that's when people start rethinking what they've agreed to.
Would that not be negotiated between the landlord and tenant? So it'd be a contractual understanding?
Well, I would suggest that we propose to the city council that those types of changes also be done in writing as well. If there's going to be any amendment to a written lease that is already in existence, if they're going to modify it, that they also include that indication, or that either the increase or the reduction also in writing, so that it's not left to this back and forth.
Is that typically not in a written lease agreement that says changes to the lease agreement shall be in writing?
No, because you can essentially, I can come and say, I want a second parking spot, and we can have an oral, essentially that becomes a non-residential. It's almost like a commercial tenancy. So I can rent you a parking spot for an extra 25 or 50 bucks a month. But it would be better, and then I can do it as a license. I can do it as a month to month, and I can say, you know what, I'm going to take away your parking spot. It could be because someone else is willing to pay more, or I'm upset with you. But I think if they also add that service to it, that we include that in some form of writing, or add that to the lease in some method, so that it's clear that the parties have established what they feel is the fair consideration, and that essentially becomes part of the tenancy.
So I think you're referring to .025 requirement of offering a one-year lease. I think in that section, you're proposing that there be some additional language that says any amendments to written leases shall be in writing.
I think so.
Okay.
And I think that is also, I'm surprised California hasn't, to some extent, added that, because, you know, with the language of an integration clause where everything must be in writing and all modifications, it's not unusual for parties to go out and make amendments. And I think if the city says, look, if you guys are going to change the terms, put it in writing as well, so that there's a record of it, so that we were not left with this he said, she said situation.
Okay. Okay, so we can address that in the next section. In this particular section with base rent, the definition of base rent or rent, the specific comment was with regard to making a distinction between those fees that are reoccurring versus utility charges. But I think you've just introduced a different concept, which is, and I'm not sure if it should appear in the definition section, but the issue of reduction of services or an increase of services in the alternative, and the corresponding rent reduction or the rent increase. So for example, if there's a laundry facility on site, it breaks down and the landlord decides not to repair it, or takes the parking spaces and then decides he's going to convert it into an ADU, and now there's no more parking. Is there a compensation to the tenant, and what should that value be? I don't think that the committee discussed that, but maybe that's something that should be discussed either now or at a later time. If that's something that you think should be a part of the comments to the council.
Well, where I also see this becoming an issue is, so typically, whenever I've represented the tenants, the landlord allowed me to have an extra spot. The landlord allowed me to keep an animal, and we're not talking about emotional service animals. The landlord let me have a dog, but when it came time to renew the lease, they said, no more pets. Or they took away my parking spot. And in some cases, it's retaliatory, and in other cases, it's because of something else. I'm just saying that once you have created a scenario that the landlord has and the tenant have agreed mutually to create either a reduction or an increase. And again, it's very important that this is something that was done mutually, that at that point in time, that a unilateral change could not take place unless, of course, it's allowed by state law. So like what LA did, for instance, LA said years ago, you cannot reduce a service like parking or something and then evict based on that. I think that's really what happens here is, in order to protect the tenant in Glendale, what you'd want to do is say is if you reduce the service, let's say the landlord says, you can't park that second car, and it's done to target the tenant. If they continue to park the second car, the landlord's going to serve a notice to perform or quit saying, remove the second car. Well, at the time that the landlord added that, there was a purpose to it, maybe financial or whatever, it was available, and the tenant relied on it, maybe they bought another car because of that, what have you. So if you're going to reduce the service, then it should be mutual. And if you're going to do it unilaterally, so if the landlord says, hey, get the car out, you can't park it there, then at least they can't evict for that. In the worst case scenario, the landlord would essentially take them to small claims court. You can get a declaratory judgment in small claims court where the judge says to the tenant, there's been a lawful modification or whatever, you must move the car out. Otherwise, you're going to be parking there and there may be a surcharge or the court may find differently. But at least it doesn't allow the landlord the ability to start tinkering with things that they've given people. And again, mostly what I've seen this is parking and animals. You can have a pet. And then they say, got to get rid of the dog. This was before, and this has always happened, and then it's not until someone will say, well, why don't you go claim it's an emotional service animal and try to get around it that way? But then what you're doing is you're also putting that person in a position where the landlord can lawfully challenge whether or not it is in fact a valid emotional service animal. And now does that tenant have the ability and essentially the fortitude to have to sit there and deal with landlords and eviction attorneys that are going to challenge that, hey, you just went and got this certificate just to get around it. You really don't have a disability. You see what I'm saying? So once it's there, let's protect both sides because they both brought it into the picture. So that way, nobody starts tinkering with the other person and using those types of obstacles to make their life difficult.
Okay, are you mentioning that all of these extras are in the beginning of getting the lease or mid, like a person's already been living there a few years or 6 months within the year lease, they now want parking or extra parking or storage?
Or an animal.
Or an animal.
I've seen scenarios where landlords originally were against pets, and then they realize that a certain number of units have emotional service animals. And they say, you know what, if they're going to have it, sure, you can have one too. That's a cute dog, okay? And then something happens between the two, and then what you don't want, the landlord's hands are tied with emotional service animals because of the law, it protects that. But you don't want the landlord saying to the tenant, okay, you better get rid of that damn dog, okay? I'm not putting up with that anymore. You did something and it rubbed me the wrong way. At that point in time, the tenant says, I'm not going to get rid of the dog because we agree that we can keep it. Unless, of course, let's say it's a nuisance or it's dangerous or something like that. But then the landlord says, okay, get rid of it. I'm going to give you a 30-day notice. Get rid of the dog. It's not for nuisance based. It's just whatever. It's a change of terms. Because by law, they don't have to. Well, that's fine. The landlord can do that. But at some point in time, then what was happening in the city of Los Angeles was landlords were being counseled to, hey, change the terms of your deal. Take away parking, take away animals, take away this. And then when the tenant who's become accustomed to that and is willing to pay for that, when you take that away from them and they resist, aha, there's your ground to evict them. So this way, what you're saying is if you agree to it, then at a minimum, whatever you've agreed to, you must abide by it, not use it as now that I've given it to you, I'm going to take the carrot back. And,
Correct.
and
But
try
when
to-
they're asking, I'm assuming they're going to the landlord asking for such things.
Something extra, yes.
Right. Shouldn't the landlord do an addendum?
They should.
Okay,
But what
because that's what
happens-
I got storage at my place, a year or so later.
Right,
And it's not included with the rent, which I love, so it's separate, it's an addendum. I can keep it, stop it, return that unit at any time. Perfect.
And that's where, again, with storage, it's a little bit easier, because that's, storage doesn't become a point of confrontation. Where I see it is with animals and parking, that's where people start to kind of pull at each other's strings. If you don't do this, then that dog is gonna be going out the door. You wanna avoid that. With storage and things like that, now, this is a potential other option, is they should, if it's something that they've agreed that this is a temporary accommodation. Let's say you only want an extra storage, but you only need it for a year until you find a house. They can very easily put in the agreement, this is a temporary, both parties agree this is temporary. But once they start making it part of the agreement, and then once someone starts changing it, because the landlord can do that with a 30-day change of terms, that's when the tenant feels like, hey, this person is trying to take something away from me. And that taking away now all of a sudden creates the confrontation. See what I'm saying?
Isn't this kind of already, though, covered in the, just cause eviction regulations? I mean, it kind of seems to me
It
that
is,
a
but-
landlord couldn't really do that, given the current
Well, I think the
regulations.
only thing that you could do is, and the simple way to do this is at the time of a renewal of a lease, any modifications that have been made between the landlord and tenant, the landlord may first offer to the tenant the option to make those modifications permanent rather than temporary. You see what I'm saying? Make that part of the lease.
We're getting into contract negotiations in the city regulating the time and place where terms of a lease agreement can be changed. I think what you're suggesting is, again, in the next section, this idea of no unilateral changes with a 30-day notice. If the parties have agreed to have a pet, they should reduce that to writing, and that they should, whether or not the city forces them to do that, at the time of a renewal of a lease or at some other time, could be problematic. I mean, if the parties agree to change the second week after they've signed a lease, well, then they could amend the lease at that point. They don't have to wait a whole year for them to make that change.
Again, if it's mutual,
Correct. And so I think those are two separate concepts. One is the idea of the changes being in writing, and the second, when should that writing go into effect? The first one, it could go in, they should be in writing, presumably where both parties sign. But when they should reduce it to writing should not be regulated to a certain point in time, because they can change their minds and change the agreement at any point. So if we can just go back and conclude that section, because we're now jumped ahead to a different section.
Okay.
So we've captured the comments that you have made with regard to the definition of base rent and rent. There was some additional discussion with regard to how a rental unit is defined. As you know, that the ordinance excludes from its rental definition, for example, duplexes and other things. The discussion from the committee was it may not be a legal unit, it may be an illegally built unit, which then makes it into a 3-unit building or a 3-unit structure. The landlord should not benefit from the illegal structure and be exempt from the requirements when he chooses to be exempt and when otherwise not. So I think that was something that we captured here. The next section is something that was brought up by a different section of CDD staff, and so this is coming to you as a recommendation from staff, and it will be noted as such to the City Council. Specifically, the ordinance currently exempts Section 8 units from the definition of rental units. There was a change in state law, and so to be current, we're going to include that amendment as part of this wholesale change. I'm going to now move on to section .025. This was the next place where the committee had some ideas for changes. This deals with the requirement of offering a one-year lease. As you know, that a landlord is required to offer a renewal of a one-year lease 90 days prior to its expiration. The committee discussed several things that related to this, and again, hopefully we've captured all of them, and if you have any other ideas, certainly like we just discussed, we can definitely incorporate that. There were comments about removing the requirement of the one-year lease in subsequent years, finding ways to simplify the requirement of the one-year lease, keeping the notice timing consistent with state law. The state law requires a 60-day notice for rent increases. This requires 90 days. Offering the one-year lease through to the second year only if the tenant rejects the lease, but continue to offer the lease if the tenant accepts it. So once the tenant says, I'm not interested in continued renewal, then maybe the landlord doesn't have to keep renewing it. But if the tenant is receptive and wants to be tied into an annual agreement, then to allow for that. And then allowing future rent increases to be governed by state law and allow tenants to request a lease at any time that is then negotiated by the two parties. And then adding to that what we just discussed, which is any amendments to lease shall be reduced to writing, and rather than unilateral changes, both parties would have to agree to material changes to the lease terms, unless, again, there's some requirement by state law.
One question. The comment at the very end of the sentence, it says, and allow tenants to request a lease at any time that is then negotiated. How does that work? Because I'm a little confused on that. If you offer the second year term a lease and the tenant elects not to go, they want to stay month to month, and then a year later you give your next increase and they say, I want a lease. Is the landlord at that time obligated to provide a lease?
Let me see if I can find my notes specific to that so I could hopefully give you a little more context on what was said. That was stated in the form of a question, just like you did last time as well. If a tenant wants to come back and ask for a lease, can he get it? And the response, and I guess the agreement was that it has to be negotiated between the two. So it wouldn't be it wouldn't just be a request by the tenant to say, I want a lease, and then the landlord is forced to have it, but the two would be open to renegotiating, potentially being subject to a lease versus just a month-to-month.
Okay. And one quick question. On the last section, when we have the definition of rental unit, I think at one point we had discussed this notion of whether or not you have a kitchen or not, whether there's a stove. Is the term rental unit going to include essentially a space that is really intended for residential occupancy, whether they give them a hot plate or a microwave or whatever it is? The person's basically living there. They'll call that a guest room in some cases, or a guest space. The whole point being is if the landlord was clearly, the mindset was to establish that there's going to be someone sleeping there, not just using it to play billiards, that is in fact a residential unit that should fall under the term rental unit.
I think the challenge with this one is when we ultimately, if it ultimately gets included, is finding a way to define those illegal conversions that were intended to be standalone and not a roommate situation, because we do differentiate between someone bringing in a roommate, which then, that person would be evicted if they, from the main, through the process, they would be exempt from this process, versus someone who is not intended to be a roommate, but actually a separate resident. And there's the one example that I'm thinking of that happened last year, but finding a way to define them and distinguish them so that on the one hand, you've got the roommate situation where someone isn't forced to cohabitate with someone they're not getting along with versus a separate residence that they created and moved someone in who now either the tenant needs to receive those protections because the landlord has done an illegal conversion and cannot legalize it, or alternatively,
Well,
well, I guess that
Where
is
I'm
it.
concerned is, so for instance, if you have a tenant, and let's say that person is occupying a room, and that person is working at a restaurant, they have food resources available to them. Or what you're seeing nowadays, a lot of these home delivery food services. So in some cases, a lot of people don't cook anymore. They order in. What I'm suggesting is, one of the things that I've never liked when I represented the tenants is this big push that, well, if it doesn't have a kitchen, it's really not it's not a residential unit. I think, I don't know if there's a way to indicate in a rental agreement a requirement on a landlord to identify this is a residential tenancy or this is a commercial tenancy. But I think once it's intended to be a residence, once someone essentially goes to sleep there night after night, it's presumed their home. So if it's a room, I don't think that the landlord should get the benefit to say, well, they're sleeping there, but I told them not to do it. I think that's, people are trying to act ignorant with stuff like that. So if the person is going to be sleeping there, they don't have a stove, they don't have a refrigerator, and again, that's because they have other means available with what's going on nowadays. I think that should still fall under the definition of a rental unit. I would afford that tenant protections, and I would count that as one of the units towards whatever units are there.
That was the intent behind that suggestion. So again, we've captured what you're saying in
Okay.
that comment.
But I think your concern was how do you distinguish between something that's being utilized as a rental unit versus just a roommate situation? Is that?
I'm saying that we'd have to be pretty specific, so we don't sweep into that definition, the roommate
Right.
Relationships.
Right. I don't know how specific we can get in that situation. I think a lot of times it requires almost an inspection of the unit to verify a few things. Going back to that one example that came out last year, I went out on that one eventually in the inspection. And there, you can clearly argue it was not a roommate situation because the door to the rest of the house was sealed off. They had their own separate exit and entry door, and things like that. So that would bolster that. I just don't know how you can capture that in a rental agreement.
Well,
But you could capture that in a rental agreement and then automatically make modifications.
Well, part of this discussion, and we're going to defer it to later comments, was some of the additional comments that came out as far as registering your unit and having it be part of the rental inventory stock. And so that would certainly capture that if that's the case. But in that specific example, not to get too technical, we had to rely on the building code's definition of a rental unit, and that was very specific. So there's where the carve-out has to come out, and we have to be very careful with how we define that. Okay, so I'm going to move to 030 now, evictions. Here we talked about expanding the definition of nuisance to include other issues that would come up on a very regular basis, such as odor or dog, animals that are becoming a nuisance. So we had talked about potentially expanding the definition of nuisance to include those types of things. In a different section of the subsection of evictions, we talked about landlord move-ins. Maybe the potential for abuse there because a landlord could keep utilizing that excuse to move in the same child into multiple units and disrupting several households over a short period of time. And there were different ideas about how to address that. I'll first talk about, to whom that it could potentially apply. We talked about providing additional protections for qualified tenants, and those would be individuals with a disability or the elderly, that there should be additional requirements on a landlord to occupy that unit for a minimum period of time so that they're not just skipping from one unit to the next. We also talked about limiting the number of times that the landlord can use this as a basis for the eviction by filing something with the city. So there would be a filing requirement with the city. And then consider other enforcement mechanisms to avoid misuse. And I don't think we got into the specifics of what those enforcement mechanisms would be, but we do have a suggestion in the section that deals with enforcement, so we can touch upon it there. This idea of creating a housing inventory came up throughout multiple meetings. For example, in the capture of the illegal units, it came up then. It also came up in this context when we were talking about it in this section, in creating some sort of a reporting requirement where the city would essentially be recipient of information that related to a resident manager or a relative moving into or utilizing that excuse as a basis for eviction. I'm going to stop there and look for comments.
The only one item that I think I'd mentioned at the beginning was that we had with the prior exemption language years ago was, how do you address the nuisance situation where the particular tenant is bad for the building? Tenants are complaining, they're afraid of retaliation, they're not exactly crazy about going to court. It may not rise to a level of a nuisance as the court would define it, but it allows an opportunity to terminate a tenancy for essentially someone that is just disruptive and knows how to work the law and makes it unpleasant for everybody, not just the landlord has a gripe with them. That was, at that time with the exemption, what it afforded the landlord was the opportunity to give the lease, and then there was the 90-day pre-termination notice that could be issued, which at least essentially afforded an out so that there was a finish line at some point. We no longer have that. So a lot of times what you're dealing with now in the city is you're dealing with situations where you've got someone who is, every time they get a notice, they cure it, or they're doing things to get under other people's nerves. Tenants are afraid to testify, and it may not necessarily be that loud that a judge in a court, especially given what's gone on with COVID, would say, yeah, I'm gonna evict you. I'm gonna throw you out on the street, because by that time the tenant's gonna come in and clean up and all that other stuff. So is there a mechanism to include in the termination some method, I don't know what at this point as I'm sitting here, but some method for the person that is doing nothing but disrupting, and you get a consensus, not only from the landlord, but of the other tenants, that this person is making life miserable, that there should be an out for everyone's sake.
And I remember the discussion, but there was not a there wasn't a proposed idea, because how would you capture that without having, 3 of the 5 tenants gang up on the 4th tenant, and and they just don't like him, and they could then potentially have illegal reasons for not liking that one person and then trying to get rid of them.
Well, remember, this person is probably, and that's what I'm trying to say, is how do you keep it a balanced perspective? Because that way, if the landlord's just not getting along with someone, it doesn't give the landlord an out necessarily. And if the tenants are doing it, it's got to be mutual. And these types of individuals are truly disruptive, but they're disruptive to right up to the level of where it's not enough to evict based on that. Again, I don't know if there is a solution for that type of a scenario, but unfortunately, there are a lot, those are the hardest situations, to be honest, that I deal with.
Right,
the
but
black
we're
and
here
white
about
scenario-
solutions, so if we don't have a
I
solution,
know,
we have to move on.
But the thing was, is that's why we gave the exemption opportunity. You know, if someone was difficult back then what the landlord did was essentially give a 1-year lease and then had to give the 90-day or give the notice. At least that way, what the landlord was saying to the tenant was, it's a 1-year notice to vacate.
It still doesn't offer a solution because at the end of the, you could start the 13th month and then you could start creating those problems. And then it's essentially at the time when this was, what you're talking about was when the ordinance was being introduced for the first time. And it was a, get out of jail free card where at the end of the year, you've tested it out, the tenant is a sound person, then the landlord will agree to rent. And if the landlord doesn't like that person, at the end of the year, they could evict without any cause, at will. That's what we were talking about, essentially, because they could come up with whatever reason to make someone leave.
Never saw it in practice, though. The only time was, at least the advice that again, this is what I saw actually happen, was saying to the landlord, there's not much you can do, but you give them another year lease, you give them a notice to vacate, essentially a year's notice. And at least now there's a finish line somewhere. So even if they renewed at that time, if you renewed it and the person acts up in year 2, then there's still a finish line, but at the end of year 3, essentially.
Okay, is your suggestion then to put that in as a recommendation? Because
think
it really goes away from, it was something that was in, it was taken out, we could put it back in as a suggestion, but
Well, one question for you is this. Back then, we didn't have 1946.2. Now you have the state provisions. Can the city legislate to add a term that would appear to be broader than what the state potentially may have in place? I don't know if you can do that now, because before we didn't have that.
Well, I think what it said is that it relates to those agencies that they had their own protections, that they could continue to offer their own protections and they wouldn't have to apply what state law said. But having said that, what you're proposing essentially takes away a critical protection of the tenants, which is not to be able to vacate at the end of a year or for no cause.
Well,
You're suggesting that if there's a tenant, and ultimately, there's a way to document that and be able to move someone out if they are truly a nuisance. But most of the time, it isn't a true nuisance. It's just two personalities not getting along. We've had those complaints. We've gone out to them. We've looked at those. You get one tenant who, turns on the music too loud, and another tenant who calls the cops when the kid's having a birthday party.
I'm talking about the person that'll come out and sees when the kids are outside and they're playing and deliberately makes it unpleasant and uncomfortable for people. I'm just telling you, from what I...
That's true, too.
Yeah,
That's true. People
I'm
will
just
do
wondering,
That's
though,
what I was
are
agreeing
we-
with you.
Are we trying to solve such a minute, very unusual problem? It
not,
just
but
seems like,
that's not the thing, though, is the whole point is almost in one of these, everybody knows when someone hasn't paid rent, or if someone has made illegal modifications, or if someone has done this, or that's fine. But where I have gotten the most questions is, how do I get this person out when they are clearly flying right below the radar? Their intent is to mess with everybody in the building and me, and they're making life miserable, and we have to sit there and put up with them until we find this cause. And it essentially takes away the person's right, number one, to contract, I think, but more importantly, that's why I'm trying to see if there is some option the city council would consider, that there's a mutual consensus between landlord and the tenants that say, this person is not good for the building, let us go. Because what you end up having is other tenants start moving, and then the landlord's stuck with it. The new tenant comes in and goes, what the heck is this? Why didn't you tell me this person is like that?
But remember-
And why didn't you do this? And and then that person says, you know what? I want out of my lease. I want my full security deposit. I want to get out. And the landlord comes to me and says, How the heck do I get this person out? Well, sorry, unless they come to that point and they say, you know what, that person's all over the internet. They know what they got to do. No judge is going to have the guts to kick this person out because of COVID and all this other stuff. And so I'm stuck constantly having to deal with this person. And you have other elderly tenants. That person might be harassing. It could be someone that's on some sort of drug or something like that. But the whole point, though, is there should be this get out of jail card, not so much in a free way, but in a way that there's a consensus that this is bad for the building. And like I said, with the exemption language, almost every time we gave that 1-year lease with you better be out, that person knows they're doing this. They will get up and they will move because they know they don't have a chance to win at the eviction. They're gone wherever they go, who knows. But then the landlord and the tenants and everybody are thrilled. Very rarely did I ever see that part of the provision of the law used to retaliate or anything. Not to say that no one would, but most of the time it was, let's get rid of the a-hole that's making it difficult for everybody.
Okay, so we've added a comment to the end of that section to include that to the council for consideration.
And I just want to say too, I agree with what you said. I understand your point completely. You're in the trenches too, so you see this. But I agree that we have to be careful that now a lot of, there's some legalities there as well with, there can be all kind of discrimination and different things that start coming into play. I just think of it like a job. If you're going to work and you're doing something that's not appropriate, you get a warning. So I just believe we can, landlords can regulate this also by warnings. We have to I just think, like you said, also, Jennifer, there's a fine line. We're not going to be able to solve everything, but I do think these are situations where the mediations can come in or some type of arbitration can come in, I think, for something like this, to be honest. And I totally agree because you're seeing it firsthand. This is what you're going in court doing. So I appreciate the scenario that you're giving us and the picture that you're painting.
But it's also kind of like the nuclear button. When one of the reasons people aren't going to fire the missiles is because they know the other side has the same button. At some point in time, if someone knows, and there's something in the law that creates at least an avenue, and again, as I'm sitting here, I don't know what it is at this second, but something that says, if you go to that point, if you're going to sit there and stare down the kids, you're going to stare down the elderly person, you're going to do this, you're going to do that, and you're doing it, the vendor gets there at 8:30. Oh, if 8:30 is not convenient for me, come back at 10. They come back at 10. 10 o'clock's not convenient. Come back at 3. And you're doing it on purpose. It's the jerk clause. Okay, that's what you're dealing with is the jerk. If they know that you can say goodbye, that person will not act up. All I'm saying is I think that the city should also keep that in mind because, and again, it's trying to keep it mutual where landlord and tenants, because most of the time, I've gone door to door and I go up to the other tenants and I say, hi, this is what I need you to do. Are you going to court? Heck no, I'm not going to court. Is this person like this? Absolutely they are. But I'm not going to go there. I got kids. I got my tires to worry about. I'm not going to get my car keyed and then all of a sudden have to sit there and deal with this. Well, if you say to this person who's a troublemaker, hey, look, by the way, now maybe the mechanism might be that if there is this type of complaint, that there's an obligation, maybe a mandatory obligation to mediate, okay? Something like that. And you say to the person, look, you're falling under the jerk clause, okay? And if you keep going with this routine of behavior, the landlord can essentially exercise that. And the landlord says, I consider you a problem. Let's go to the city. And at that point, I think it's going to be easier for potentially other tenants to talk to a city inspector, someone that goes to the door and says, hey, look, candidly, can you tell me what the problem is? And then you're sitting at a mediation and the person says, I've heard this, as opposed to going through the formal procedures of evidence and presentation of witnesses and hearsay and all this other stuff. I'm just telling you again, this is my experience.
Yeah.
These are the problems that, again, rent, didn't pay, paid late, whatever, those are simple. Those are black and white. You can call it balls and strikes. This is the one where it's kind of discretionary, was the runner out of the base path or not, And I think that we have to have that type of a protection. And I think hopefully most of the time that won't be used.
And we'll try to capture it, I think now that you're saying it, in a way that includes the other side, which is where you've got the jerk clause of the landlord being nitpicky and argumentative and
agree.
figuring out ways to, show up right at 8 a.m. instead of, knowing full well the person works a night shift or whatever.
Agreed.
So,
Agreed.
okay, we've captured that, and I would suggest that we move forward. We continue to the discussion to 0.033, rent-based termination. The idea of banking, I think there was one specific question that would come up for staff pretty regularly, and so this was something that we were suggesting that we consider. And the reason was there is an accumulation of 21% with a cap of 15% at any one time, but there was no cap on the look back. How far back do you go to say, oh, the rent was not increased in 2019, and now it's 15 years later, and they say, but we only increased it by 5% back then, and now records aren't there or anything like that. So being able to do a look back to only 3 years, still being able to capture the other components, which is the up to 21% and then no more than a 15% increase. This was just to help with simplifying some record keeping on both the landlord and the tenant. So that was the rationale for the banking. 0.035.
Will there be also a clarification that it may transfer from prior owner to current owner?
I'll add that. The next section about relocation fees, we discussed quite a bit. And as you know, relocation comes up in two instances. We have relocation when there's an eviction. We also have relocation if the rent increase is more than 7%. And so we dealt with them separately. There wasn't a way for us, I think, to just identify a single value to say the relocation will be X. The discussions that we had around this was, and I'll just go through the option. Option one is it relates to evictions based on eviction. Relocation fee is greater of the amount of 3 times the greater of the tenant's current monthly rent in effect or the FMR for a comparable unit plus $2,000. This is just a little bit of an increase from what it is currently. Relocation is 2 times actual rent plus value of security deposit with possible escalator for larger projects. I'm not sure I know what that larger project is, though. The relocation, I'm sorry? The relocation fee is twice the FMR plus CPI plus 2,000, whichever is higher, and then the council to review it every 5 years. I think the one common thread was that the relocation value shall not be suspended in time, but somehow the council shall build into the relocation value an escalator clause so that it continues to stay current with the times. For further consideration, the committee suggested differentiating between small owners and multiple owners. This was something that we had discussed. If the total number of units were a higher count than the value of the relocation could increase, and consider whether the landlord owns in the aggregate less than 4 units and or lives on the property. So these are all additional factors to consider when establishing the relocation value. The committee also suggested perhaps considering a different formula for illegal conversions and capturing this type of information in a housing inventory and habitability program. So again, this idea of creating an inventory came up in the context of the relocation fees. With regard to the second type of relocation, when the rent increases above 7%, the suggestion was to remove the AMI condition currently in the code, and the scale should be modified to something else. You didn't say what the something else was, I think, in that suggestion. Committee also suggested that a tenant ought to demonstrate that they've begun the move-out process somehow prior to receiving any relocation benefits. That's slightly different than what we say now, what the code says now, which is provide the first 50% and then the second 50%. Currently, the code excludes the payment of relocation fee for any rental unit that receives. Now, moving into a different concept under relocation, the code excludes the payment of relocation fee for any rental unit that received that was built before 1995. The suggestion was that there only be a 15-year look back consistent with AB 1482. I see the look of confusion. What this means is that there was, at some point, state law had, to encourage new development, state law had said that these types of restrictions would not apply to anything that was built after 1995, because then you wouldn't have rent control, your units would not be rent controlled, your units would not have some of these restrictions that cities were able to implement. But then what happened was 1995 is now 30 years ago, almost 30 years ago. And so the homes that were built in, the buildings that were built in the 90s and early 2000s, they're not subject to rent control protections throughout the state. And so when the state adopted AB 1482, they said, rather than having an arbitrary year, why don't we have it have a 15-year look back from today? So you go back 15 years, and that's what it is. So the suggestion from the committee was to mirror that, so that rather than exempting everything pre-1995, to have a 15-year look back.
Is that a moving 15-year look back, or that's just from when 1482? I can't remember.
I think it's a moving,
So it's always 15 years, okay.
And then there was section J within .035. The suggestion was to provide a reference in the notice to the city website for additional information. Right now, there's specific language that needs to be in a notice indicating to the tenant that they have the right to relocation, et cetera. So there's some set language in there. The suggestion was, at the very least, to also include the city's website where a tenant could potentially obtain additional information.
So, quick question. On the relocation, one of the things we talked about was the difference between the rental increases above the 7% versus the other provisions. And I thought one of the things, the consensus that we had was, rather than being different formulas, we just have one relocation formula. Is that your understanding?
I think that was the suggestion. The problem with that was the second one, the relocation value is tied into what the rent increases. So if the landlord was offering an increase of $1,000 per month, then the relocation value is tied into that, it was 3 times or 4 times the value of now proposed rent increase. And so that's where the difficulty was in trying to determine what that should be. But I think as a separate suggestion that all relocation be the same, we never agreed to an actual value of what that ought to be or how that value ought to be determined.
Right, I agree with that statement. My thing is again, kind of looking at what the city of Los Angeles does. The city of Los Angeles, they have their classes, but it's not based off of rent increase versus the other one. This is your relocation amount. And I think the distinctions they made is between qualified and non-qualified tenants. And I think recent years they had added the mom and pop, smaller household, smaller building situations. Again, that formula that we have with the rent increase one is really a hard one to understand. And I don't know, tenants can't calculate it, landlords can't calculate it, and the majority of the time what happens is the landlord says, hey, look, I'm going to give you $3,000, $3,500, and the tenant goes through the ordinance, they can't figure it out, and they say, great, thank you, and they're out. And they're technically entitled to more. There's been several times where I've corrected tenants and said, no, the amount that they're giving you is less than what you're entitled to. And part of the reason that that's happening is because people can't understand how to calculate all that stuff. So I think if you said, for instance, just using, let's say, the one that jumps out at me is, you know, because we use this FMR and all that other stuff. Most people don't even know where to find the FMR, unless the city's going to include that on their website so that it's very easy for people to find. But if, let's say the state says the state law is 1 times rent, we have 2 times rent plus your security deposit. That's something that people understand. My rent times 2 plus my security. Oh, okay. And they'll fight for it. They'll fight for it because they know what that is. But I can very easily write a very wordy letter with the current statute, the way it's written, and get you to take $2,500, give you a 60-day notice, because most tenants are not going to waste their time trying to sit there and figure it out. And if you throw something with a comma in it, they're probably going to think that that's probably right. And I'll tell you, if it comes from a lawyer, they're going to definitely think it's probably right, and they're going to be out the door, and they're going to get less than that they're entitled to. So I dealt with a situation currently where the tenant came and said, I'll take $5,000 to leave. And based on a 2-bedroom unit, the amount that was owed was $54.44 based on the current formula. And we said, look, my recommendation to the landlord entity was, let's pay them the $54.44 for the extra $444. It's better to comply with where the current relocation assistance is. And that way down the road, there's no questions that you tried to snicker or anything like that. And when I asked the tenant, I said, you know, I said, look, by the way, you're going to get half, and you're getting $27.22 now, and you'll get it $27.20. They said, why isn't it $2,500? I didn't know I'm entitled to that. Oh, I saw that, but I don't know what that means. And that was in a notice that was originally given to them with a 60-day notice. So and that notice is 3 pages long, and I've tried to spell it out for them. They still don't get it. So let's simplify this, please, so that the tenant can sit there and argue it themselves and say, hey, this is easy for me to understand. I know what 3 times rent or 2 times rent or security deposit is. I want my money and I'm gone, you know? So why do they need to call me to figure out if they're getting the right amount? That's ridiculous. So this FMR, CPI, and then there's this talk about if you're under a certain income or whatever. I think the city should spell that out for tenants. If we're going to use lower income as a factor, you have to say, if your income is below, you know, X dollars from all sources of income, you know, $31,200, put the number out there for people. People shouldn't have to sit there and do this calculation. And rest assured, most landlords just want to pay it, get out. When I told my client, look, the difference is $400, it was like, just write it. Get it over to them. I don't even want to deal with it. Are they moving? Yes. Fantastic. Let's be done with it.
Is there a specific value that you have in mind, or is there something that the committee's considering? Because if I understand the city of LA's, it's pretty substantial. It's in the $20,000 range.
City of LA is a horrible example of how to run the city. Okay, again, I said this at our first meeting. This is the city of Glendale. That's the city of Los Angeles. And if you want to see the problems the city of Los Angeles is dealing with, you're welcome to drive through there and you'll see it. I think whatever our city council decides, because that's all we can do is make a recommendation, is it something that's reasonable and it's easy for the average person to figure out. This FMR, CPI, all this other stuff, you know, most people are now with the state having enacted CPI. Landlords are calling me and say, when is CPI? How do you figure out what the CPI thing is? I think that's even, but let's say it's a consumer index, fine. But I think for the city of Glendale, if we're going to do this, we don't want to be back here 10 years from now. That's why the council review is very important in the future, because at that point in time, if circumstances change, pro or against, whatever, the council should make that modification. But simple.
I think I was definitely for around option 2 times the rent, plus the security deposit. I think we all were pretty much in agreement about if it's a mom and pop, definitely looking at that if it's 4 units or under, I believe. But definitely, and then what I'm kind of confused about is how, well, the tenant probably would have had increases depending on how long that they've been there. So at the end of the day, they're going to still get their worth back, their money, the current rent, plus the moving. I think the gray area for me is when they could get that money. Because if they're going to stay within their means and move to another unit with the same rent or what have you, they're going to need that money, including the deposit. So I think that's where my gray area would be, not waiting for them to move out, or just either giving half and the remainder upon move out, or just something early. I think they may, tenants may need that for their new unit.
That's what we have currently, is you give them half within 5 business days, and then 5 within 5 business days that they vacate. One thing that I like about the LA ordinance, I still think we keep the first half within 5 business days. But if a landlord wants to hold back, and again, I recommend to my landlord clients, pay it up front, is to, if the tenant, like you indicate here, if they are moving, they should be able to get the second half of their relocation payment, assuming rent is current and everything else, if they can verify that they, in fact, this is for the purpose of moving to a second location.
That's what it was that we agreed on.
Another example I'll tell you is recently with one of the landlord clients that did pay relocation, the tenant moved out. I was current in the rent, paid everything. They gave him back their security deposit too. And the tenant left large bulky items out in the trash bin, bed frames, mattresses. That was an extra burden on the landlord to have to move it, to also that the security deposit was gone. They had to pay for the hauling, or they were able to get the large bulky item stuff. But at this point in time, the interesting thing is with almost every landlord client that I've dealt with, those costs, while it still kind of stings, as long as they know they have possession and the tenant, again, that finish line is very important. With that finish line, like, I don't care. I just got to move on. I'll work on it. That's part of the cost of being a building owner. So there are these inherent attributes that happen. But like I said, the simpler we keep it so people can go their different paths, the more this stuff will naturally and organically go to its natural resting point.
Are we having a tenant pay their rent for that month? Let's say they are paying June, but they have to be, there's an expectation for them to be out in the middle of a month, for instance.
They only have to pay prorated rent.
Okay, that's what I want to make sure.
In fact, if the landlord takes more than the conclusion date that they've designated, it can be construed as a waiver of the notice, and you have to kind of start all over again.
Well,
So,
again, to make sure that's clear, because
yeah, it's always prorated. It's always prorated.
just have to make sure.
And again, from a practice standpoint, I've also seen many landlords, if they give them a 60-day notice, 20 days in, the tenant says, I found a new place. Can I get a couple of my money back, and can I get my prorated rent back? And more than less, more landlords will say sure, because again, the key is possession. When you have the unit back, you can jump in, do whatever you need to do, get the next person in, whatever it is.
provided they're an honest landlord.
Yeah, but no, I'm saying they will do that. I mean, it's kind of silly if you say on the 29th day, I want 1 day of
Of
rent
course, of
prorated.
course.
But most of the time, you won't get a pushback. Most of the time, you will not get a pushback.
And I think it depends, I'm just going to say this too, and I think why the verbiage, like we're saying, is so important. I think it depends on the type of landlord. So when we're getting into the illegal units and different things like that, when we're getting into a smaller, landlord occupancy of units, we get into that, I think that's where it can get muddy. So as long as, like we're saying here, the verbiage is very clear for the tenant to understand, the landlord to understand, we can just reduce all the muddy water.
But you have to let it do its organic.
Sure.
Let it go to its natural point.
For sure.
People are not looking for confrontation. Trust me on this. They really aren't. And the easier
But what I'm more concerned with, when people can get away with something, they can. And I think this is where, people like, when people are calling, for instance, I'm going to bring it up again, the Glendale Tenants Union and different things and other support, this is where they're finding out. Some landlords think they can get away with things when they feel or believe the tenants don't have the knowledge. That's what I'm concerned about, because a lot of tenants do not, and there is sometimes pushback when they believe. You can just Google that and see that most landlords think that tenants are stupid when it comes to their rent.
Which is my point exactly. I'll give you 2 hours to figure out what the FMR is on a 3-bedroom unit that you're supposed to pay. You won't find it. You won't find it. Because you know what? You got to look under Long Beach. How many people?
It's on the city's website, by the way.
Well,
And
yeah,
anybody
but
wants to know, it's on the
I'm just
city's
saying
website.
but most people are not going to go look at city. Some people, if you said, look, what's the FMR? Some people may not realize that the city may have spoon-fed that.
Most people call too, so we get phone calls like that ask that question.
I know, but she's intelligent. If I told her to go find the FMR, would you be able to find it in 2 hours? I can tell you this, when the new one comes out in a couple months, it takes me a few minutes to find it. So, and it's just, if we simplify it.
Definitely simplify. Okay.
That has been a common theme throughout the past 9 meetings, I think. Okay, so moving to point 050, the affirmative defenses, there was a comment about capping attorney's fees in the code. There was some differing opinions on that. I think we've captured that. Moving on to point 070, penalty for violations. One of the things that the code allows is for, there's 2 routes for penalties. One is the prosecution route, the other one is the administrative process. And we're currently looking into what the fees would be, the fines would be for violations of various sections of this code, and how to implement the administrative process, instead of the prosecutorial process, which could take a lot longer, versus the fines component could potentially go a little bit faster. So we're looking at what those fines would be, and then incorporating that into this. I think we needed a separate heading after that, which was other suggestions, or rather other areas of consideration, because we are now moving away from the actual review of the ordinance and the additional tasks that were given to the committee, in the form of considering whether or not there should be some type of a mediation program. And while we didn't get into the specifics, and we likely will provide the same type of presentation that we did to the committee, to the city council, I think it was pretty clear that everyone was suggesting that there be some type of a mediation program. That it, at the very least, mandate that the parties participate. There was some discussion between whether it should be binding or non-binding. The binding component, mediation by definition is non-binding. The binding component would mean that the agreement would be reduced to a contractual understanding, and it's that contract that becomes binding. not the ruling of the decision, it's not even a decision maker. The mediator is someone who tries to bring the parties together for a resolution. And if part of that coming together includes a written contract that both parties sign, that then becomes something that they could point to if they decide that they want to go to court. And so that could possibly be a hindrance for the parties deciding to participate, but it was an area of discussion. We had some additional discussions. Should that be in-house? Should that be contracted out? Should there be a person? So that entire presentation will also be made to the City Council with a comment that the committee certainly favored the idea of implementing some type of a mediation program, and that would largely depend on budget. It would depend on, and so we think that that's an area that would get further discussion and potentially get kicked back to the committee for fine tuning once we have a better idea at least of budget and what the council would want to do. The committee also discussed the benefits of creating a mechanism for tracking whether units are built illegally. We talked about tracking the number of vacancies, possibility of charging a vacancy tax of sorts, providing greater staffing for code enforcement, and we did spend, I think, an entire meeting talking about educational workshops and outreach, and the committee certainly being in support of that. So all of those would be incorporated into a single staff report that would go to council. We will let you know when that meeting is. You would all be welcome to attend that meeting. You would be afforded an opportunity to speak if you wanted to. I'm not really sure when that will be. It kind of depends on when we put the report together, and then we have to ask for a spot on the agenda, and so the city manager's office will direct us as to when that will be. And that's it from my part. Do you all have anything to add?
Just at our last meeting, we're gonna hold off on until we get direction from council. We take this report back just in case they have additional comments. They want something for you to look at. Maybe the relocation fees, they want you to narrow it down to something more concrete. So until then, we won't have the last meeting, just so gives council an opportunity to, get more feedback on everything you've discussed. Other than that, anybody else have any comments?
I actually had a question on the mediation. If, I can't remember what we talked about as far as if say a tenant is having a problem and the landlord doesn't want to participate, if the tenant requests from the city, are we saying the landlord would have to? I was just trying to figure out where we landed on, how it actually would work, I guess.
We didn't have a consensus on, because the ideas were very different. Some were the mediation program should be voluntary, some, and if you remember, we did a voluntary but binding, mandatory and binding, and so we had the different options, and so we will capture that in the report and provide the variety of responses that we received, because we don't have a single recommendation, and so we also don't want to tie the committee's hands in being forced to decide this way or that way on something when the council may just say, we're not going to have the budget for this for some time, so,
Right. Any callers?
No callers.
All right.
I have a question. Since we've been here over a year, on behalf of my fellow committee members, isn't it time for a raise? Just kidding.
Take that to council as well.
I love that $46 I get.
So next on the agenda is comments from ad hoc committee members and staff. Do we have any comments? Okay. So next is new business. We don't have any new business, so that brings us to adjournment. Our next meeting is undecided, and I will post it and let everybody know when we have a date. Is there a motion to adjourn?
Sipan, how long ahead of that meeting do you think you'd be scheduling it? Just because we're heading into summer and,
I don't think we'll have the council meeting until at least July.
okay. I'm just saying,
it'll
be
be
mindful
after.
of summer vacations and plans that people
It'll
are going to
definitely
be.
be after July, probably sometime August or September, right? Thinking, depending on how full council.
Yeah, I don't know if it'd go out to September. We might poll the committee and ask about maybe us having a special meeting, just so that it doesn't go too long, rather than wait for every month and check in the fourth Wednesday of the month, so.
Right, I'm
We'll
just
have to
saying. in
play it
case
by
people
ear.
have
We
plan-
understand.
in
Yeah, we
case-
understand.
you
Does it, let me just poll the committee. Most plan on taking off vacation and things like that, July or necessarily August?
July?
July?
September.
I would say after August for me, only because my kids are back in school and I'm going to be here. So before then, it's a little bit more of a,
So July really sounds like the dicey month then.
yeah, I think June,
Okay.
July are very dicey.
Well, then hopefully we can come back and meeting in August.
I mean, our meeting can be flexible, but the council, the meeting at council that you're all going to be invited to, that we might not have a lot of
No, I'm talking
control
about
over.
our meeting, just in case. Because you'd mentioned in case they want us to give them,
Budget item going on.
the reason I said is in case you're saying that they want us to give them feedback,
Right.
if they can't have that meeting until we give them feedback, that there's enough opportunities that we're all here so that we can congregate.
Correct.
When is our next meeting? That's what we're talking about,
That's
but the next meeting isn't gonna be until.
Until they say so.
So the idea is that we'll take this report to council. That date is not controlled by us, so we don't know when that date will be.
Right.
As soon as we know that date, we will let you all know so you have an opportunity to attend. After that meeting, we'll have direction on what council wants us to do next. Once we receive that direction, we'll check with everyone and figure out a time that works for everyone. And given what council's calendars look like, we anticipate it'll be in the latter part of summer, when we all come together again.
Okay, I just wanted to be clear, I didn't know if we were gonna have another meeting and then still meet with city council, but we're talking about just being inclusive
Right.
with that. Okay,
And I mean, council might not want any further discussion on it. They might accept whatever you've given them and make a decision there, so you never know.
But they do have a heavy calendar in June, I know that. So if that's the case, and then July doesn't work for us reconvening, we might be looking about in August, really. We'll see.
So do we have a motion to adjourn?
I motion to adjourn.
Right, we stand adjourned at 7:27 PM.